Hello and welcome to Unwiring Tech. I'm your host Ranjana and today I will be explaining the Draft Digital Personal Data Protection Rules 2025 released by the Ministry of Electronics and Information Technology MeitY on 3rd of January 2025. So what are these rules about? How will they affect businesses and citizens of the country? Let us first set the context. The draft DPDP Rules 2025 are designed to operationalize Digital Personal Data Protection Act of 2023. They aim to ensure that our personal data is collected, stored, and processed responsibly while giving us greater control over it. Let's start with the highlights of the draft rules. First, the rules ensure that entity that determines the purpose and means of processing personal data called data fiduciaries, which includes e-commerce, social media, and gaming platforms, must provide clear and simple notices to individuals or data principals before collecting their data. These notices should explain exactly which data is being collected and why it is being collected, with no legal jargon or hidden terms in it. Data principals can also withdraw their consent easily, exercise rights under the Act, and file complaints with the Data Protection Board being established with these rules. Second, consent managers. Rules outline specific provisions regarding consent managers to allow users to give, manage, review, and withdraw their consent for processing their personal data by data fiduciaries. Now the question is, who can be a consent manager? To be eligible as a consent manager, companies or individual must meet key criteria. A net worth of at least Rs 2 crore, adequate technical, operational and financial capacity, proven business structure, earnings and volume of operations. Responsibilities of consent manager includes user access, maintaining an app or website as a primary service platform, secure approval from Data Protection Board of India, enable users to grant or withdraw consent, track data sharing and maintain consent records, retain records for at least 7 years, prevent data breaches and maintain secure data sharing. Consent managers must directly fulfill all the obligations and there should not be any subcontracting. They should also conduct regular audits and report to the board, and avoid conflict of interest by direct affiliation with any data fiduciaries. The DPBI, that is Data Protection Board of India, plays a central role from registering consent managers to ensuring compliance. It can request information, issue compliance instructions, or even suspend registration to protect user interests. DPDP rules also stipulate when and why state can process your data. Under the new data protection framework, the state and its agencies can process personal data to provide subsidies or benefit, services, certificates, license or permits, all which are issued under legal framework, government policies or through public funds. However, such processing must adhere to specific standards outlined in the Act to ensure data security and transparency. This particular provision has raised many concerns about the increased surveillance of the state. Next is protecting your personal data. Data fiduciaries are required by law to implement security measures to keep your personal information safe. They should use tools like encryption, masking, or virtual tokens to secure data, and should ensure that only authorized personnel can access sensitive systems. They should also track data access to detect unauthorized activities. And if something goes wrong, they ensure service continue by maintaining data backup. They also have to maintain logs for at least a year to track breaches unless otherwise required by law. According to the rules, when hiring external data processors, contracts must enforce strict security standards. So what happens if there is a data breach? Data fiduciaries must act quickly to notify both you and authorities. You will receive a clear explanation of the breach, what happened, when and where. possible consequences and steps you can take to protect yourself, information on what the company is doing to address the breach, contact details for a representative to answer your questions. The authorities also get updates within 72 hours, including details of the breach, steps taken to prevent future incidents, and any responsible parties identified. Now, what happens to the unused data? If a company no longer needs your data for the original purpose and you haven't interacted with them for a specific period, they must delete it, unless you need the service or want your data retained. Just log into your account or contact them. Companies must also publish contact information for a representative or data protection officer to assist you. They are required to respond to inquiries and ensure transparency. Now, one of the very critical parts of these rules are children's data. When it comes to children's data, consent isn't just a box to check, and there are specific legal safeguards in place. The draft rule mandate verifiable parental consent for any user under 18 years and prohibit behavioral tracking of minors. Platforms are also required to verify guardians' identities. This can involve checking existing identity records, using virtual tokens, or verifying details through trusted services like Digital Locker or DigiLocker. A company called a data fiduciary must confirm that the person providing consent is an adult and a legitimate parent or guardian. When it comes to individuals with disabilities who require guardianship, similar rules apply, but with additional checks. The guardian must provide proof of their legal authority, whether appointed by a court, a designated authority, or a local level committee under laws like the Rights of Persons with Disabilities Act or the National Trust Act for a specific condition. Along with this, significant data fiduciaries every year must conduct data protection impact assessment and audits to ensure they are safeguarding your personal data effectively. And here is the kicker. They have to report any significant findings to the Data Protection Board. We live in a world run by algorithms, whether it's the ads you see or how search results are prioritized. The significant data fiduciaries are required to ensure that algorithms they use don't pose risks to your right. As far as data localization is concerned, the rules require certain types of personal data to remain within India depending on the sensitivity of the information. Now let's talk about one of the most important part of these rules, rights of the data principle. Under the new rules, company must clearly explain how you can access the personal data they have on you, request its erasure if needed, and even nominate someone to manage your data rights in your absence. It's about putting power back in your hands. These organizations are required to publish easy to understand instructions on their website or apps. No more hidden policies buried under layers or legal jargon. But what happens if things go wrong? Companies must have systems in place to address grievances quickly and effectively. They also need to manage consent better. That's where consent managers come in. Independent entities that help you manage and track your data permissions across different platforms. In the world of data, not all processing is for commercial gain. There are exemptions for research, archiving, and statistical purpose. The idea is to encourage innovation while still maintaining a standard for data protection. There are also cases where certain data processing obligations don't apply. For example, for specific classes of data fiduciaries or purposes listed in legal schedules. These exceptions are carefully regulated to maintain a balance between privacy and practical needs. Now, what do these rules mean for different groups? For you and me, we'll have a greater control over our personal data. It will be easier for us to understand how our data is being used and even to withdraw consent if needed. For businesses, the compliance will require investment in new systems for data management and security. While this is a step forward for accountability, smaller businesses may face challenges in adapting due to increased operational cost. For digital ecosystem as a whole, these rules promote transparency, trust in the system, making India a global leader in data protection. Every policy has its hurdle, and DPDP rules are no exception. Implementing parental consent requirements might be complex because most Indians are not technologically well informed. Smaller businesses may need support to meet compliance standards due to technical and financial constraints. Public awareness is the key. If people don't know their rights, they can't exercise them. To address these issues, government could either provide financial and technical support to them. Can we suggest some ideas for the same? MeitY is inviting feedback on these draft rules until February 18th through the My Government portal. This is your chance to weigh in and shape the future of data protection in India. That's all for today's episode of Unwiring Tech. Thanks for tuning in.